first event organized together with ITOTAM. We are currently also scheduling further events for the next periods. It is not 1 year we started our negotiations and discussions together with ITOTAM about our mutual cooperation, and we very quickly learned that the cooperation with ITOTAM is extremely flexible, very friendly, and we hope it will bring efforts to both sides, and mainly to businessmen from both countries and from both regions. Let me also to express many thanks to our colleague from ITOTAM, but also to other institutions which are supporting us, mainly, but not only, the Czech diplomatic mission in Ankara, consular mission in Istanbul, the Turkish diplomatic mission in Prague, but also the governmental agencies, Czech Trade, Czech Invest, and other institutions. Thank you very much and good afternoon.
Thank you very much, Professor. And by that, we'll proceed with the short presentation about the arbitral institution. We now return to our Secretary General of İTOTAM, Ms. Senem Bahçekapılı-Vincenzi.
Hi, good afternoon from Istanbul, distinguished panelists and distinguished participants. Firstly, I would like to thank you for all of you for participating in our today's webinar, and welcome to my presentation. Today, I would like to briefly inform you about Istanbul Chamber of Commerce Arbitration and Mediation Center and about our activities and our projects. Istanbul Chamber of Commerce has been offering arbitration service since 1979, but at that time the rules were designed to resolve the disputes between its members. So I will define that time rules a kind of sui generis rules, but designed for resolving disputes among its members. But Istanbul Chamber of Commerce has played a key role in promoting, supporting, and further developing arbitration over the years. In order to provide its arbitration service parallel to the international practice and aligned with the international modern arbitration rules, Istanbul Chamber of Commerce, as of 2014, completed its work on setting up its autonomous arbitration center and on drafting its new rules. And founded in December 2014, Istanbul Chamber of Commerce Arbitration Center, İTOTAM, is an independent institution that provides efficient, reliable, and impartial arbitration service. İTOTAM services and arbitration services are available for commercial disputes, regardless the nationality of the parties, the language of the arbitration, the place of arbitration, and the applicable law. So the parties are free to designate their arbitrators, to select the applicable law, the language, and the seat of arbitration. And arbitration, while completing its work on Autonomous Arbitration Center, we took into consideration the ICC arbitration rules, Constitutional 2010 arbitration rules, and other modern arbitration institution rules have been taken into consideration. And the arbitration court and the arbitration center are the only bodies empowered to administer these rules. And arbitrations are administered by our arbitration court, which is composed of experienced arbitration practitioners. And let me briefly introduce our arbitration court members. President Professor Hakan Pekçentes is the president of our arbitration court, and he's a law faculty. He's a professor at Law Faculty Galatasaray University, Civil Procedure and Bankruptcy Law, Professor Hakan Pekçentes, and Vice President Professor İlhan Helvacı. He's also Law Faculty and a Civil Law Department. Professor Ali Yeşilırmak, he's from İbn Haldun University, Civil Procedure and Bankruptcy Law Department of İbn Haldun University Law Faculty, and Associate Professor Ebru Şensöz Malkoç from Istanbul Commerce University Law Faculty and Private Law department, and attorney at law, Mrs. Nimet Baş. She's a founding partner of Nimet Baş Bozat Attorney Partnership. And following the foundation of ITOTAM, with following years, ITOTAM, taking into consideration the recent developments on arbitration in international arbitration world, revised its rules. So in 2016, there was a slight rise of our rules, but there were two major important issues. First, it was in 2016, we have adopted our emergency arbitration rules and expedited rules, which is a fast track arbitration. So for disputes to certain amounts, there's a fast track arbitration. And then after, in 2017, we provided to also mediation service. And the current rules are rules of 2021. And in this 2021 rules, there were some important amendments. The new provisions for complex arbitrations are included under rules, such as joinder of additional parties, consolidation of arbitration, claims between multiple parties. Those were already, our arbitration court already developed practices to address this complex arbitration issues. But within the new rules, there are clear provision under our rules. And also third-party funding provisions also are included under rules. We took mainly ICC new 2021 rules. We took into consideration while working on, while revising our arbitration rules. And also, let me briefly also inform you about our international activities. ITOTAM is a member of IFCAI, which is a International Federation of Commercial Arbitration Institutions. And we have developed many cooperation agreements with different arbitration centers all around the world. And we are engaged in different international and national projects with other institutions at both national and international level. And such as ISPRAMET is a member of, ITOTAM is a member of ISPRAMET, Network of Arbitration Centers in the Euro-Mediterranean zone. And also we are following ASCAME, which is the Union of Chambers of Mediterranean Chambers. And one of the most following activities that we are following since many years is that ITOTAM is following also ancestral working group 2 and 3, which works on dispute settlement and investor state arbitration. We, as a member of Turkish delegation, we are following this also ancestral meetings. And before also concluding my presentation, I would like to also just inform you about our training program. That in order to promote and to strengthen the use of arbitration and mediation or ADR mechanism, we are regularly organizing training programs. Also during COVID-19, we organized different training programs and webinars, online conferences, especially with also for law faculty students training programs. We have also concluded a cooperation agreement with Istanbul Bar Association. So we are, in order also to raise awareness of arbitration and other ADR mechanism, we are organizing these conferences, webinars regularly. And having said that, I almost, this brings me to the end of my presentation. And thank you very much.
Thank you very much, Mr. Sena. Now we proceed with Horacek, who is the president of PRIAC Arbitration Court.
Thank you, Dr. Alvaci. Let me introduce briefly Dr. Horacek. Dr. Horacek, president of our arbitral institution. Next to me, on my right, on your left, is a leading arbitrator from Czech Republic, having arbitration experience since over 30 years, not only from Czech Republic, but from many other countries and jurisdictions, is also practicing lawyer, is a university lecturer in law and commercial law, and having experience from the ICC proceedings, serving together with me for a couple of terms, for many terms, as a member of the ICC International Court of Arbitration, also having also experience in sport arbitration, and he will introduce to you, to all of you, our arbitral institution. And just a brief remark, I will introduce the members of our presidium of the board of our arbitral institution of PRIAC before starting their presentations, because all of them will have a short speech, short presentation in course of the 2 days event. Thank you. Dr. PRIAC.
Thank you, Alexander. Good afternoon, ladies and gentlemen. It's a great privilege to have such a nice event. Even I would prefer to have it in person, either in your nice Istanbul or here in Prague. And I still hope it may happen next year. Probably also with some other possibility, because we are planning so-called PRIAC Day. It will be in 2 weeks now, this year, and maybe you have agenda with you, so please note 23/11/23, 23 November 23 is a plan that we have a so-called PRIAC Day, and we may make it more international. So I would say only one word, which probably I pronounce correctly in your language, teşekkür. I like that, and I am very happy that we have a chance to be together. Let's go to the most important point, which probably everyone wants to hear, and this is how the arbitration works. And I have to rely to my predecessor, and thank you very much. The arbitration is very much similar in the Czech Republic, so I don't want to keep long talking about the plans, about the rules, etc. But there are two issues, two tools, which I believe are most important for all arbitration anywhere in the world. And this is really the proper arbitration proceedings. And as you already mentioned as well, and I like that very much, it's training of arbitrators. I would say these two tools I like very much because it leads us or helps us to make the arbitration very efficient. And it is especially important for us as the commodity exchange, because what we need is to have very quick and very efficient decision. And I am proud to say that this year, the average of arbitration proceedings within our court is 2 months. The shortest decision was in 2 weeks, and the longest decision was in 3 months, which is, I think, very much record as to arbitration worldwide. And as I have said, first tool is scrutiny, as we know that from ICC. And I like it very much because what we do, we keep always the eye on the arbitration proceedings to keep the arbitrators and the arbitration proceedings very fast, efficient. Why? Because it saves the money, as everyone wants that. But also, the proceedings must be correct and fine. We never, of course, interfere with the merits, but we interfere with proceedings and follow exactly the rules step by step, whether arbitrators are able to do so or not. And finally, and I have to thank to my colleagues, because we share this, we definitely scrutinize the award. So we check the award, whether the award corresponds to the rules and whether there are everything, I would say, liabilities of arbitrators and requirements of the rules met. And now it works. Hopefully it will work further. And then I am going to the second tool, which is the training of arbitrators. And I think the training of arbitrators in 2 directions. One direction is, of course, the proceedings, how to abide the rules, how to work with them. And second, which is probably most important for us, because of a commodity stock exchange, is whether and to which extent the arbitrators understand the trading of commodities, especially electricity, gas, and wood, which are the most tradable, I would say, commodities, and also the most discussed and arbitrated commodities in our arbitration court. And we have a plan which probably will work, that we will accept only arbitrators who are properly trained in this respect to our list. Maybe one point, not to keep you long and discuss it longer. It is a big question for us, and we always discuss it among us in the presidium of the court, whether or not to have a closed list of arbitrators. Me personally, I have to say that maybe I will not be then handled by the colleagues, is that I am for the open list of arbitrators. On the other hand, I must admit, with all due respect, after 5 or how many years, that the training of arbitrators and the arbitrators who are on the list are really these who have a very good knowledge of all arbitrators, arbitration aspects, not procedural one, but also the material one as to the commodities. So maybe I should go back and step back and say maybe the closed list of arbitrators for this moment for the stock exchange or commodity exchange is okay. Let me finish by that. And as I have said, I hope we'll be having a chance to meet in person and see each other either in Istanbul or in Prague. Have a nice afternoon all, and I just pass the word back to moderators. Thank you very much.
Thank you very much, Maciek. Before giving the floor to the representatives of the commodity exchange, let me to add a couple of words about the PRIAC and about the feedback of PRIAC. The permanent arbitral institutions may be established in the Czech Republic only by law or pursuant to the special law. The PRIAC, our arbitral institution, has been established in 1996. There are only 3 permanent arbitral institutions in the Czech Republic. We are specialized in commodity disputes, however, not only the commodity disputes. This term is extremely broad currently. Our international arbitration institution is specialized and especially focusing to disputes related not only to the Czech Republic, but to the broader Central and Eastern European region. And we are very happy to cooperate with ITOTAM to extend the cooperation to the greater European and Mediterranean area, because we know that ITOTAM has a very, very good position and experience in this region, greater Mediterranean region. Now, let me please to introduce other 2 speakers on this table. The first, Mr. Čermák, who is Vice President of the Commodity Exchange Board, and at the same time, he's on my left, on your right. And at the same time, he's Vice President of the PRIAC. And the second speaker, or the main speaker at this moment, is Mr. Miroslav Hájek, who is Secretary General of the Commodity Exchange, and the gentleman will provide you a short presentation of the Commodity Exchange.
Okay, thank you. Good afternoon, ladies and gentlemen. I'm very pleased that I can introduce the founder of the PRIAC, the Czech Moravian Commodity Exchange, Kladno. I will say commodity exchange or exchange, it will be shorter. The Czech Moravian Commodity Exchange was established in 1994 under Act on Commodity Exchanges. Since 1995, it has been operating as an organizer of exchange markets for industrial, energy, and agriculture commodities in the Czech Republic. It's a central marketplace for trading electricity and natural gas supplies for end customers. In 2002, activities were expanded significantly when the exchange participated in the establishment of a liberalized electricity market in the Czech Republic obtained license to organize electricity trading, and established a separate trading section, the Energy Exchange. In 2010, this energy section was directed to organize trades in the physical supply of electricity and natural gas to end customers in the Czech Republic. The exchange allows the conclusion for a period of 1 to 3 consecutive years or shorter. In the long term, 5 to 8 million MWh per year are traded by thousands of contracts on the energy market, with a financial volume exceeding $1 billion. Energy exchange is a central marketplace with a highly competitive trading environment. In addition to hundreds of companies, almost all ministries, about 600 towns, including clients like water and heating companies, transport companies, and universities buy energy here. In August 2005, the exchange started to systematically support the organization of timber trading, which was completed in 2006 with the creation of the Timber Exchange section. In 2020, the section was fundamentally upgraded with the opening of an electronic timber market. On the Timber Exchange section is traded over 1 million cubic meters of timber per year. In 2018, the exchange opened a fuel supply market within its industrial commodities trading section. The market allows trading in gasoline and diesel in daily, short-term and long-term contracts. In markets that are systematically organized by the commodity exchange, the exchange creates specific environments, conditions, and mechanisms that make the trading process of the trading participant more efficient. These conditions and functions, including in particular, the standardization of commodities and trading conditions, centralization of supply and demand, transparent pricing, aggregation, and the publication of information as a price guide for the entire commodities market. In 1995, exchange established a specialized arbitration court, PRIAC, and the PRIAC arbitration clause is used in contracts concluded on all markets of commodity exchange. All registered traders at commodity exchange can use the benefits of resolving commercial disputes at the arbitration court. The speed of decision-making and the high expertise of the referees are considered the biggest advantage of PRIAC. The arbitral ruling is issued by PRIAC within 2 or 3 months, as already said, as standard, while it is normally 1 to 2 years for the state justice system of the Czech Republic. Commodity exchange, in cooperation with the Confederation of Industry of the Czech Republic, fully supports the effort of the new PRIAC presidency, which in the last 5 years has begun to develop international cooperation, which is beneficial for a business and the legal certainties of businessmen for partner countries. Thank you for your attention. That's all for me.
Thank you, Dr. Alvaci. I hope you will allow me to add a couple of words about our mutual cooperation, about the mutual cooperation of both our arbitral institutions. Probably we are due to say to the attendees of this seminar, of this webinar, that as entering both our arbitral institution, the cooperation agreement in the early June of this year, we also agreed, and it is part of our cooperation agreement, of our cooperation memorandum, that we will intensively cooperate when resolving disputes related to Turkey and to Czech Republic in such terms like recommendation formation of special trained arbitrator cooperating when exchanging information about the law of both countries, information about the case law practice, to may offer the highest standard and highest competency in hearing and resolving disputes related to both countries and to both our greater regions we are specialized in. Thank you very much for allowing me to add this information.
Not at all. So we may now continue with the last speaker of the opening remarks section, Mr. Çağdaş Özelmiş, who is from the International Relations Department of Istanbul Chamber of Commerce. Mr. Çağdaş.
Thank you very much. Good afternoon to all, and dear participants, dear all esteemed professors. I extend my regards to all. My name is Çağdaş, and I have been working in Istanbul Chamber of Commerce since 11 years, and in the International Relations Department. And I know the time is limited for the opening session, and in this sense, I'm going to deliver a speech of maybe 5 or 6 minutes. I will try to introduce Istanbul Chamber of Commerce in a couple of slides. And now let me share my screen. Is it okay? Can you see it?
Yes, we may.
Okay, let's start. And established in 1882, the Istanbul Chamber of Commerce was the first and the founding chamber of the Balkans, the Middle East, the North Africa, and Anatolia. And we recently celebrated the 140th anniversary of the chamber. Istanbul Chamber of Commerce is a non-profit professional organization with a semi-governmental status. And it is one of the 3 biggest chamber organizations worldwide by member number and capacity, with 700,000 member companies. And Istanbul Chamber of Commerce is the representation of an agency of Istanbul and its region and Turkey's economy, as Istanbul alone is similar to a large country. And thanks to its revenue, it generates, the city surmounts 23 European countries by itself. And our members account for 39% of Turkey's national income. And these figures display Istanbul's continuous existence as a center of trade and economy in this geographical and country. Istanbul Chamber of Commerce is a global chamber as well. We are not a chamber to include only Turkish companies, and over 46,000 companies, either founded by foreigners or with foreign capital, are among our members. And without a doubt, there are Czech companies among these companies as well. 36 companies are either established by Czech business people or companies with Czech partners. We have been conducting activities to create added value, not only for Istanbul, but also for whole Turkish economy. And every year we host high-level and protocolar delegations. We organize trade missions abroad. We perform national participation to fairs and exhibitions. And we organize sectoral meetings as well, and like seminars, conferences, workshops. And we realize regional, international B2B, business-to-business meetings. And also we provide professional guidance to SMEs, like access to finance, company establishment, etc. And in addition to this, we host professional committees meeting, and we prepare expertise reports on multiple sectors, and we provide broker services to obtain visas, like Schengen visa, the UK visa, the USA visas as well, the commercial visa offshore. And I will talk very briefly about our organizational structure. As you may see in the slide, we may divide it in 2 main parts, the elected bodies and the appointed bodies. In elected bodies, we may count the professional committees, the Chamber Assembly, and the Executive Board. And the General Secretary and the departments constitute the appointed bodies of the Istanbul Chamber of Commerce. And in this slide, you see a chart showing the main activities carried out by our chamber. And roughly, we can say we may divide them into two parts, two main pillars. The services authorized by law, and the other one, the member-oriented support services. The first part, the first group, our chamber, and through the authorization granted by the law 5174, delivers following services like company establishment transactions, trade registry transactions, the commercial archiving and storing records, and issuing commercial documentation like foreign and domestic trade documents. And the second group, we see the member-oriented support services. And Istanbul Chamber of Commerce engages in development of new services to address members' needs and challenges throughout their economic and commercial lifespan. And we can divide these activities under four main pillars, like internationalization, improving business climate, training, raising awareness, and networking. The first one is the internationalization. And in this part, we can say we focus on providing necessary interventions to increase and support global competitiveness and market expansion of Istanbul enterprises. And these activities are like trade missions, B2B events, exporting programs, national participation to fairs and exhibitions, counter fact sheets, and the projects as well. And the other one is the activities regarding the improving business climate. These activities concern targeting improving overall business environment of Istanbul region, and deliverables under this pillar span from lobbying to development of tailored unilateral or multilateral projects. And as I said before, lobbying, sectoral meetings, and carrying out economic surveys and prices indexes for sure, and corporate projects. And we can also say the arbitration and mediation center can be considered as a service for improving business climate as well. And the last one is the third one, the training and raising awareness. And these activities are based on works and studies on SME needs and challenges. And Istanbul Chamber of Commerce acts as an intermediary organization providing necessary training and as a hub for the dissemination of up-to-date clarification of any related matters. And you can see here the activities regarding the services of training and raising awareness. The vocational training and education is one of the most important. And the last is the networking activities. Istanbul Chamber hosts several networking events in addition to regular monthly assembly and professional committee meetings. And besides, the Chamber also expands our sphere of influence by becoming members to notable Chamber networking or collaboration platforms. For example, we organized a big organization like World Marketing Summit, and we are also member to 3 important associations and institutions, international institutions. And we are aware of the need of bringing a new initiative to EU affairs. And as we have been conducting nearly half of our foreign trade activities with EU countries, as the Istanbul Chamber, we have been striving to overcome our problems with the EU by developing cooperation with European countries' commerce chambers. And to this end, we are building effective relations with 3 Europe-related institutions, like the Association of the Mediterranean Chambers of Commerce, we call it ASCAME, and Alliance of European Metropolitan Chambers of Commerce, IMC, and the Danube Chambers of Commerce, DCCF. And as the Istanbul Chamber of Commerce, we have also our subsidiaries. I will talk about them briefly. First of all, Istanbul Commerce University. Istanbul Commerce University is a private university founded in 2001 by the Istanbul Chamber, and it is well known both with its undergraduate and advanced degree programs. And we exist in the education realm with Istanbul Commerce University, which delivers education to about 10,000 students and graduated 20,000 students. And the second of them is the Technopark Istanbul. As Istanbul Chamber, we founded Technopark to develop technology and to enhance innovation in Turkey. And our Technopark is one of the countries and region's most prominent defense industry centers. Technopark Istanbul is operating in selected sectors, including defense, aerospace, marine, advanced electronics, energy, life sciences, and advanced materials and industrial software. The third of them is the Commercialization Center, Bilgi Ticaretleştirme Merkezi in Turkish, and we call it as well Idea to Business. And Istanbul Chamber has considered the economic and commercial capacity of Istanbul with all other related socioeconomic statistics and developed the Idea to Business Commercialization Center of Istanbul in 2016. And we launched the center to increase the entrepreneurship of our members and in Turkey. And since its establishment, we have supported and guided over 2,000 enterprises and over 4,000 entrepreneurs. World Trade Center, another subsidiary, to promote international commerce.
Mr. Özdemir, could you please summarize it? We're running out of the program. Okay, last two slides. And the Istanbul Chamber of Commerce founded the World Trade Center in 1982. And the facility of the center includes 11 fair halls. And we hold numerous fairs and exhibition events in this hall of World Trade Center. And the last of them is the Convention and Visitors Bureau, ICBB. ICBB's main goal is to represent Istanbul around the world and to seek international associations and corporations planning to hold high-profile international congress and events. And I am finishing my words here. I hope I kept my promise to talk briefly. And thank you for your attention and thank you for listening and extend my regards to all. Thank you. Thank you very much, Mr. Özdemir. So we now proceed with the session one. The moderator of the session one is Professor İlhan Helvacı, who is the Vice President of İTOTAM Arbitration Court. Professor Helvacı, I leave the floor for you.
Thank you very much, Mr. Burhan Helvacı. We have 3 sessions today. In the first session, we will focus on specifics of arbitration in Turkey and Czech Republic. In this first session, we have 2 colleagues, 2 distinguished colleagues. The first one is Professor Dr. Cemile Demir Gökyayla. I would like to introduce you very shortly, my colleague. Professor Dr. Gökyayla is the president of the International Private Law Department of the Faculty of Law at Istanbul Bilgi University. She teaches international arbitration law, international commercial law, foreign investment law, and international private law. In the first session, we will listen to our distinguished colleague, Professor Alexander Belovlavek. I would like to introduce you very shortly. He lectures on 3 universities in Czech Republic and in Poland. Main topics are private international law, international arbitration, international investment protection, international trade law, and international finance. Without further ado, I would like to welcome the presenter, the first presenter to deliver the presentation, Professor Gökyayla. The floor is yours. You have the floor.
Thank you, Professor Helvacı. Good afternoon. I am honored to be invited today to share the futures of arbitration in Turkey. I thank the organizing committee for their efforts and their invitation. To begin, Turkey is an arbitration-friendly country. And the last decade, awareness of arbitration has been increasing. Since 2001, modern international arbitration law has been in force. The law is based on the Amsterdam Model Law of 1985 and inspired by Amsterdam arbitration rules of 1976 and Swiss International Private Law of 1982. In short, for 21 years, Turkey has been a Amsterdam Model Law country. Domestic arbitration is regulated under Civil Procedure Code, which is also based on Amsterdam Model Law. There are only a few differences between domestic and international arbitration. However, these are significant. I would like to admit that I'm speaking under control of Professor Pekcantes, who actually one of the authors of both codes. Professor Pekcantes was in the drafting committee of international arbitration law, and he was also the head of the committee of civil code procedure. So I am talking under his control. Since 1992, Turkey has been a party to New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards and the European Convention on International Commercial Arbitration, like the Czech Republic. Turkey is party to Convention on Settlement of the Investment Dispute between states and the national of other states. Young practitioners are enthusiastic about being arbitration lawyers. Arbitration agreements are becoming more and more common in international and also domestic commercial contracts. In this presentation, I would like to introduce the features of international arbitration law. International arbitration proceedings seated in Turkey are subject to international arbitration law. The law defines what is international arbitration very broadly. Let's talk first about the arbitrability under Turkish law. The dispute at the disposal of the parties are arbitrable. The law excludes dispute related to the rights in rem for the immovable in Turkey, only in Turkey. Generally speaking, according to the Turkish Court of Cassation, labor, consumer, and residential lease dispute are still highly debatable and require a close assessment of the case at hand. The dispute arising from mergers and acquisition are arbitrable, no problem at all. Shareholders' agreement disputes are one of the most common disputes solved through arbitration. I think in Turkey, the most common arbitration agreements are in construction contracts. My next topic is the arbitration agreement. The law repeats the definition of arbitration agreement in the Amsterdam Model Law and also in the New York Convention. Turkish Court of Cassation decision on the arbitration agreements are parallel to the Swiss Court of Decisions. Accordingly, the parties' consent to arbitration must be clear and without any doubt. Pathological arbitration agreements, on the other hand, are a big problem. The Court of Cassation intends to hold them null and void. We advise the practitioners to use standard arbitration clauses prepared by arbitration centers instead of having their clause. I would like to touch on interim measures in arbitral proceedings very shortly. Under the law, the arbitral tribunal can order interim measures to the parties, but not third parties or state agencies such as Land Registration Office or Customs, etc. The tribunal's order cannot be executed under the execution law as well. Alternatively, the parties can apply to the state courts for interim measures. Not only to the arbitral tribunal, but also the state courts are available to the parties to have an interim measures under international arbitration law. In domestic arbitration, the things are different. In respect of the constitution of arbitral tribunal, parties appoint the arbitrators. In the case of failure, in ad hoc arbitration, state courts, in institutional arbitration, centers boards appoint the missing arbitrators. The independence and impartiality of arbitrators are vital issues. The sole or the third arbitrator must have different nationalities from those of the parties. Everyone may act as an arbitrator in Turkey. There is no nationality limitation. My next issue is the rules governing the arbitral proceedings. The parties can agree the rules governing the proceedings subject to a few mandatory rules in law, which are the same as in ancestral model law. The law recognizes ad hoc and institutional arbitration. The parties can refer to institutional arbitration rules such as PRIAC or ITOTAM rules, arbitration rules. Ancestral arbitration rules may be referred for ad hoc arbitration proceedings. If there is no such agreement between the parties on the procedural issues, then the arbitral tribunal shall conduct proceedings in accordance with the law. The critical issue for the tribunal is respecting due process. The parties are free to choose the language of the arbitration and the law applicable to the merits. For example, the place of arbitration is Istanbul and the language is English. The governing law is Czech law. Foreign lawyers can represent parties before the arbitral tribunal. There is no requirement to be registered or licensed here or have malpractice insurance for foreign lawyers. A Czech party may be represented by a Czech lawyer and appoint a Czech national as co-arbitrator in a dispute with a Turkish party. Following the Turkish international arbitration law, I will carry on with the features of ITOTAM arbitration. I will be careful not to overlap with Ms. Sinan Bahçekapılı's presentation. I would like to emphasize that actually ITOTAM is the first arbitration center of Turkey and was established in 1979. ITOTAM arbitration is open to every party, company, or individual. It provides, there is no requirement for membership to the Istanbul Chamber of Commerce or to be a Turkish company or nation. ITOTAM is an independent, neutral, and impartial non-profit institution. It provides dispute resolution services for both international and also domestic parties. From my professional point of view as acting as arbitrator under ITOTAM rules, I'm glad to say that ITOTAM arbitration and mediation rules answer the current needs of international arbitration and mediation proceedings. As Ms. Bahçekapılı told a few as she told the rules based on modern arbitration, institutional arbitration rules. ITOTAM offers fast-track arbitration and also emergency arbitrators. So I have three important issues that I attach big importance deciding on the effectiveness of an arbitration center. First, the appointment of the arbitrators. The ITOTAM court appoints the court arbitrator nominated by the parties. So the parties nominate the arbitrator, but the court appoint. That is like in ICC arbitration. Upon the respondents' challenge validity of arbitration agreement, the courts make a prima facie decision on the validity of the arbitration agreement and continuing the arbitral proceeding. This is like ICC and also DIAC, Dubai International Arbitration Center, and also SIAC, I think. Under ITOTAM rules, there is no scrutiny procedure. This is a the big difference from ICC arbitration and also SIAC arbitration. Both have scrutiny procedure. ITOTAM doesn't have. ITOTAM offers a model arbitration agreement. You can find this model arbitration agreement in the booklet, but let me read it loudly for the audience who are interested to make an ITOTAM arbitration agreement. Any dispute or claim arising out of or relating to this contract or the breach, termination, or invalidity thereof shall be finally settled by arbitration in accordance with the rules of arbitration in Istanbul Chamber of Commerce Arbitration and Mediation Center. Based on my experience, I can say that this is a very valid, very clear arbitration agreement under Turkish Court of Cassation's previous decision. And this is also very similar to the one of the ICC arbitration agreement, ICC model arbitration agreement. So this is well internationally and domestically well established wording. Of course, drafting their arbitration agreement, the parties should consider the place of arbitration. I don't think that under ITOTAM rules, the place of arbitration must in Istanbul. It may be anywhere on the earth, I think. So you can make an arbitration in Prague under ITOTAM rule, or an arbitration in Istanbul under PRIAC rules. Everything is perfect, fine in Turkey. The parties should consider the place of arbitration, the language of arbitration, the law applicable to the arbitration agreement, and also merit. And the parties may think also opt out the emergency arbitral rules. And this concludes my presentation. Thank you for your patience and for your invitations. Thank you.
Thank you very much, dear Professor Gökyaylan. Thank you very much for your very valuable explanations. And you respected your time schedule. Thank you very much. Now I would like to invite my distinguished colleague, Professor Alexander Belolavec. Dear Professor, you have the floor.
Thank you, Professor Harvacim. Thank you also to Professor Gökyaylan for presenting the Turkish arbitration law. Let me do the same regarding Czech arbitration law. Arbitration enjoys in the Czech Republic a very long-standing tradition. The very first permanent arbitral institution in the Czech Republic has been established already in 1949. And there was progress for a couple of decades where the arbitration became really very popular, even until 1995, the arbitration was in the Czech Republic limited to international disputes only. The Czech Republic, or rather the former Czechoslovakia, was also is also very popular as a neutral place for resolving international disputes without having any relation to the Czech Republic. It means like as I mentioned already, like this neutral point, neutral place. The current regulation is the law. The current law in effect is the Arbitration Act as of 1994, in effect as from January 1st, 1995, as amended in course of the past years. There are in the Czech Republic also no differences between international arbitration and domestic arbitration. For both types of arbitration applies the same law, with some exclusions like identification of the applicable law and recognition and enforcement, which is subject of the Private International Law Act. However, recognition and enforcement will be subject of a special presentation in the session 3 of our today's webinar. Arbitration is a very, very popular way of settlement of private and mainly commercial disputes in the Czech Republic. We don't have exact statistic details and statistic figures because there is no exequatur in the Czech Republic. It means arbitral awards don't need confirmation by the court. That's why we have just statistics only about cases, arbitral awards which are subject of enforcement by law, enforcement by courts. Earlier on, when I was asked by the colleagues from abroad how many arbitrations there will be conducted in the Czech Republic, I usually replied there are some 10, 20, as maximum 30,000 cases. I was a member of the special commission established by Ministry of Justice for amendment to the Czech Arbitration Acts and working this commission between 2010 and 2012. And the very first question I asked the Ministry of Justice at that time and starting the job in this commission was how many arbitration will be conducted and how many awards will be rendered in the Czech Republic per year. If the Ministry of Justice has some figures, and the reply was shocking for me because the Ministry of Justice at that time counted as a minimum 100,020 to 100,050 awards to be rendered per year in the Czech Republic, which means that about 1/4 of all civil disputes in the Czech Republic will be decided by way of arbitration. This number a little bit decreased because of the new law which prohibits currently the consumer-related disputes to be decided in arbitration since 2016. However, still the number of the disputes is quite high. And if talking about 120,000 disputes per year, you also have to reflect that the Czech Republic is a rather smaller country with the population counted to 10 or 11 million of people, which is rather uncomparable with Turkey. As in respect to arbitrability of disputes, in the Czech Republic, those disputes are arbitrable, may be subject of arbitration or subject to arbitration agreement, which are of private nature, which fall within another way, which fall within the competence of courts of general jurisdictions, and those such disputes which may be settled by the parties by settlements. There are some exclusions in terms of negative definition of arbitrability, except as the exception are disputes arising, for instance, from the enforcement of decisions, and except of incidental disputes in insolvency proceedings. As I already mentioned, there is no exequatur in the Czech Republic, which means that awards have the same effects as final and conclusive court judgments once they are delivered to the parties. Czech Republic didn't explicitly adopt the ancestral model law. However, the Czech law, the arbitration acts, and the practice is quite or almost in full compatible with ancestral model law. There are some exceptions, like, for instance, the arbitrability, which is a little bit narrower. As I already mentioned, disputes to may be subject of arbitration must be of private nature, must fall within the jurisdiction of Court of General Jurisdiction, and must also be subject of may also be subject of settlement by the parties. However, on the other side, the issue, the term private disputes, property disputes will be interpreted very, very broad. Just for instance, also family law disputes of property disputes may be subject of arbitration, which is, however, not really, most probably not really of interest for the attendees of this webinar. However, I do know, and my predecessor already mentioned the company disputes, company-related disputes, which are in most extent also arbitrable, and there is in fact not really discussion on this issue in the Czech Republic. Also, a high number of employment disputes which are of property nature are arbitrable. On the other side, consumer-related disputes are not arbitrable since 2016 and cannot be subject of arbitration agreement. Arbitration will be understood in the Czech Republic as a type of civil procedure, which means arbitration follows the same aim as litigation. Arbitrators will be understood in the Czech Republic, and from the Czech perspective and Czech doctrinal perspective point of view, only different decision makers and law finders will be understood as another authority. This term is very important, which means there are in fact they meet the same aim as the courts of general jurisdiction. Even they are of fully private nature. The courts of general jurisdictions are not allowed to intervene in any manner, or at least freely, in arbitration, except for those issues which are specifically set by law, like decisions on independence of arbitrators, like set aside will be subject of special presentations by another two colleagues from our presidium in the session 2. No claims may be subject to arbitration and litigation at the same time, which means the Czech practice and also the Czech case law confirms in full the competence principles. The law honors the freely expressed will of the parties who wish to have their disputes to be heard and resolved by arbitrators. Hearing the case in arbitral proceedings does not constitute the denial of legal protection, denial of justice. In the opposite, as I already mentioned, the Czech law, the Czech doctrine follows the doctrine that the arbitrators fulfill the same aim as courts of general jurisdictions. The same principles of fair trial, therefore, apply in arbitration, except of those resulting from a specific nature of arbitration. So the parties have a very, very broad opportunity to agree on the procedural rules. In fact, the law on arbitration, the Arbitration Act of 1994, set only for very general standards like the equal status, the equality of the parties, and also the parties must be provided with a full opportunity to assert their rights. What is very important in the Czech Republic and for arbitration conducted in the Czech Republic as a seat of arbitration is the predictability. The Czech courts and the Czech case law set a very, very high standards for predictability of the proceedings. Unpredictable acts of arbitrators could also constitute denial of the full opportunity to assert the parties' rights. Eliminating any unpredictability in arbitrators' decision is very important, and I expect that the colleagues of mine will also talk about this issue in their presentation on regarding set aside of arbitral awards. In the proceedings, also reasonably applied the Code of Civil Procedure. Just briefly, arbitrators must be of full legal age and have full legal capacity. There are no differences between foreign and Czech arbitrators, which means nationality does not play any role. Also, qualification in law is not required for appointment of arbitrators. Even we, of course, do recommend usually to have at least one arbitrator in the tribunal enjoying the full legal qualification. Arbitrators shall keep confidential and all circumstances in which they learn in connection with their office as arbitrators when serving as arbitrator. Deliberation of arbitrators is then subject of absolute confidentiality. Hearing will always be held in camera. If the arbitration agreement lacks the determination of particular persons as appointing authority serve usually the Court of General Jurisdiction, except for those disputes which are subject or for which apply also the European Convention of International Commercial Arbitration as of 1961, where the appointing authority is the Chamber of Commerce. Nevertheless, it of course does not apply for cases for which apply the rules of a permanent arbitral institution, as for instance for PRIAC we have in our proceedings as appointing authorities serve the president of our court. As for the application law, briefly, the parties are completely free to set the applicable law. If they don't if they don't agree for applicable substantive law, we have to the arbitrators in arbitrations conducted in the Czech Republic, the applicable law will be identified pursuant and in accordance with the Private International Law Act. As a very last remark, there are no differences, as I already mentioned, in domestic and international disputes. In the Czech Republic also often will be hard and resolved disputes which don't have any relations to the Czech Republic. It means the Czech Republic will also be used as a neutral country for resolving the disputes. The same also the Czech parties may set for seat of arbitration out of the Czech Republic, for instance, in Istanbul or elsewhere in Turkey, even the dispute does not have any international aspect, does not meet any international aspect. As we are very, very limited in time, probably I may propose to all of you, to the colleagues from ITOTAM, that probably the attendees of this seminar may also address their specific questions to us, and also their suggestions and ideas how to improve and support their business relations between both countries or both regions. We also agreed, both our arbitral institutions, that we will meet on a regular basis, and I can probably inform the attendees that our next meeting will take place in Istanbul on November 30th. And if the attendees of our seminar will address to us, to ITOTAM or to PRIAC, their specific questions, ideas, we can use this opportunity in 3 weeks to discuss them and to inform about our suggestions on our websites. Thank you very much, and returning the word to Professor Helvaci and to Istanbul. Thank you.
Thank you very much, Professor Belovlavek, for your very valuable explanations and for your invitation for our suggestion and for our questions. Thank you very much. I think I should close the first session. Thank you very much, dear Burhan Helvaci, Mr. Burhan Helvaci. Thank you very much.
Thank you very much, Professor Helvaci. So we now may proceed with the session 2. I welcome the moderator of the session 2, Professor Alexander Belovlavek, the Vice President of the PRIAC Arbitration Court. Professor Belovlavek.
Thank you. Thank you very much, Dr. Helvaci. Let me to take the word very briefly. I will introduce, first I have to apologize, as I am moderator for the session 2. Probably it would be in accordance with the protocol rules to start with the presentations of our Turkish-seated colleagues. However, I will proceed in accordance with our protocol, which is the schedule of our webinar. That's why we will proceed with the presentations of the Czech colleagues. It is an honor for me to may introduce you 2 members of our presidium, namely Dr. Řezníček, right on my right, on your left, and as father speaker, co-speaker, Dr. Holub, both very experienced arbitrators with long-standing practice as arbitrators, but also as practicing lawyers, mainly focusing on international practice, commercial law practice, private international law practice, both also having academic feedback and career. Just simply let me to give the floor to both colleagues of mine who will present to you the conditions and practice of set aside of arbitral awards in the Czech Republic.
Good afternoon, ladies and gentlemen. Let me thank to Mr. Professor for good introduction of our persons, and it's my honor to present you. The specific institute of setting aside of arbitration awards according to the Czech law. I found this institute very important for every practicing arbitrator, and we can find it in the section 31 of the Arbitration Act.
It's necessary to stress out that this institute does not serve as the remedy against the arbitrational award. The remedy, if we understand it as the review of procedure and substantive and legal correctness of the decision, is exclusively a review by other arbitrators, and provided that the parties has agreed on such a principle. The purpose of the institute of setting aside an arbitration award is to enable judicial review or of whether basic conditions of hearing and deciding case before arbitration tribunal have been met. The General Court does also perform its supervisory function in relation to the arbitration proceedings. Arbitration award has to be issued, so it could be set it aside. Without issuing arbitration award, it's not possible to file issue for set aside, and which means that during the arbitration procedure couldn't be filed this type of issue. The application for setting aside of arbitration award to the court must be filed within 3 months of the delivery of arbitration award to the party seeking the setting aside arbitration award. The filing of application shall not affect its legal force and enforceability. The application doesn't have a suspensive effect, but the court may, at the request of the debtor, postpone enforcement of the arbitration award. Condition for postponing of the enforcement of the arbitration award is that exists serious prejudice threat connected with the immediate enforcement of the arbitration award and the possibility of concluding that the applicant for setting aside of the arbitration award is justified. You can see that only serious threat must be prejudice, and without this serious threat couldn't be enforceability of the award postponed. The filing of a motion to set aside arbitration award shall not affect the legal force of the arbitration award or its enforceability. However, the filing of such application may cause a delay in enforceability. Both the institute of setting aside of arbitration award by the court and the institute of suspending the enforcement of the award are very similar in purpose and copy the relevant international standards expressed primarily in New York Convention and European Convention on Commercial Arbitration. Conflict with public order is not a ground for setting aside arbitration award under the Czech law, but we are talking only about the procedural side, because procedural side is in section 31 of Arbitration Act very clearly set it, and we are not talking about public order in international law. The arbitration award may be set aside only from procedural grounds, so the court is not entitled to review the arbitration award on substantive ground. We have seven reasons for setting aside the arbitration award. We can split this reason into the 3 big sections. First section concerns with the lack of objective arbitrability. Arbitration award will be set aside if was made in matter in respect of which a valid arbitration agreement cannot be concluded. This is the lack of arbitrability, and the court shall decide on its own motion. No party has to propose this to the court. Court has to check it all the time ex officio. Second type of reason is the lack of arbitrability, but we are talking about subjective arbitrability, which means that the arbitration agreement is otherwise invalid or has been annulled, or it's not applicable to the agreed matters. These are grounds for, other than the grounds of lack of objective arbitrability. We are talking about the lack of will of the parties, lack of subjectivity, absence or invalid conclusion of arbitration agreement, lack of definition, and so on. In this case, court will examine whether this ground was raised in the proceeding before the arbitration, before the party started the case. This is a very important point, because if the party will miss this period, this objective is not longer to be used. On the third part of reasons are the procedural grounds. These are the grounds consisting in the manner in which the proceedings were conducted and when the manner of the arbitrator's decision making. We are talking about the grounds where the arbitrations will not comply with the procedure conditions. There was no proper appointment of the arbitrator. This is another ground, and therefore there is the error in the procedure of appointing arbitrators. These are also the cases where the parties has been denied opportunity to actively participate in the appointment of the arbitrator, or where the appointment has been influenced exclusively by only one of the parties. We can stress out that the possibility to choose arbitrator is one of the principles of arbitration, and if the basic principle is breached, then the court will set aside the arbitration award. In this case, we'll also court examine whether this ground was raised in the proceeding before the arbitration started the case. If this is not established, the court must dismiss the application for annulment. Fourth reason is that the arbitration award was not made by majority of arbitrator. This is procedural side. Every arbitration award must be agreed with the majority of arbitrators, and if not, there is no reason to be issued and it must be cancelled. Fifth reason is that the party was not given the opportunity to hear the case before the arbitrators. This is the most frequent reason for annulment for trial annulment of the arbitration awards. Many of these cases are merely attempts to make the institution of motion to set aside an arbitration award inadmissible. Yeah, just okay. So I will just point last two conditions and we'll quickly finish. The arbitration award condemns party to a performance which is not requested or by the beneficiary, or the performance which is impossible or unauthorized by the domestic law. This is the sixth reason, and the seventh last reason is that it's established that there are no grounds for seeking in retrial in civil proceedings. These are just the basics of the principles for setting aside. And I would like to thank you for invitation and the possibility to speak here. And thank you for attention.
So the co-speaker is Dr. Holub. I only will ask him to inform us and to take his presentation in a summarizing way, as we are short in time.
Thank you, Professor Bielohlavek. I'd like to stress only a few remarks in this case. As my colleague Dr. Reznicek has already mentioned, in principle, it is possible to review. It's possible to use the setting aside procedure only as a control function and not as a review on a substantive basis. So therefore, only the procedure would be checked, and basically there are two main reasons why the arbitral awards can be set aside. One of the reasons is lack of competence of the arbitrators, and the other one are substantial procedural defects in the proceedings itself. Here, I would like to mention a little remark about the development of the case law, which also influence later the legislation of the arbitration in the Czech Republic. First, I would like to stress out that PRIAC, out of principle, has never been involved in consumer-related cases, and it cannot be. The reason for that is very simple, that PRIAC can only deal with issues which are related to the commodities which are traded on the exchange, and obviously consumers do not trade on the exchange in principle. However, it is very important to mention that consumer-related cases and understanding of the arbitrability in the past has influenced the understanding of the arbitration as such, not only by general public, but also by business people and other lawyers. What happened in the Czech Republic in the years around 2000 is that there were created very many private arbitration centers, which actually didn't maintain its professionality, and unfortunately to say, sometimes they were even in a way connected to one or the other parties. In the Czech Republic, as I said, it's possible to use the permanent arbitration courts, which are established either by law or based on law, such as PRIAC, or it's also possible to use the ad hoc arbitrators. The private arbitration centers I was speaking about were mostly those who were basically in all cases those who were acting as ad hoc arbitrations. So what happened at the Supreme Court level is that even though some of the arbitration awards were obviously not following fair process, there was sometimes missing references to the orders, and sometimes there was some suspicion that even the arbitrators were in a way connected to the parties. The Supreme Court in 2008 and even later, the Constitutional Court declared that as long as the parties decided for such arbitration centers, they were free to do, they had autonomy of their will, and actually what happened is that they declared such a reference to such private arbitration center as valid. In the same time, in 2008, the High Court of Prague actually declared that such arbitration clauses were not validly agreed, and arbitration clauses were therefore invalid, which led to certain chaos in the decision making of the various courts, and it led to a change of law, which actually in 2012 allowed to the ordinary courts, to the general courts, to review the arbitration awards on the grounds of conflict with substantive law in the case of consumer disputes, which was actually not really something we all wanted, because out of principle, consumer disputes are not very suitable cases to arbitration. And as we know, this is exactly the same understanding in Turkey, as Professor Koyala has already mentioned. As in Turkey, it's prohibited. This development led to what Professor Bělohlávek already mentioned. In 2016, there was another amendment of the law of 1994, and consumer disputes were completely excluded from the arbitration. This gave certain clarity into the arbitration law in the Czech legal system and Czech business environment. And since 2016, we come back to those 7 reasons for setting aside of the arbitral awards, as Dr. Reznicek has already mentioned, and we are aiming to more stable arbitration world and a place where there's more trust again in the business and legal sphere. I hope that this very positive trend will continue even in the future, and that we will have a very friendly arbitration space here in the Czech Republic. Thank you.
Thank you to both my colleagues, and let me to present you the other speaker on this panel in this session, who is Professor Dr. Ebru Şensiz-Malkoç. Professor Malkoç is Associate Professor on the Istanbul Commerce University Faculty of Law, Department of Private International Law. She graduated in private law. Main topics of Professor Şensiz-Malkoç are private international law, conflict of laws, international arbitration, international investment law, and international trade law. She's a member of ITOTAM Arbitration Court, permanent, but also attorney at law, advocate, author or co-author of many monographs, articles, or other writings, and she pays as one of very, very eminent arbitrators and specialists in international arbitration and private international law. And we are happy to have you with us, and we are looking forward to your presentation. Please, the floor is yours, Professor Şensiz-Malkoç.
Thank you, Professor Belohlavek. I would like to start by greeting everyone, and many thanks to, again, Professor Belohlavek, PRIAC, and İTOTAM General Secretariat to organize this webinar. I will share my screen, if I can. Yes. Sorry.
I think this is not the correct presentation. Yes, this is the correct one.
Yes. Thank you very much. My presentation is about setting aside of arbitral awards with regards to Turkish arbitration law. In Turkish law, there are two different laws applicable depending on whether the dispute subject to arbitration has a foreign element or not. The first law is Turkish Civil Procedure Code, the second one, a Turkish International Arbitration Law. In Turkish law, before 2001, before the implementation of Turkish International Arbitration Law, both national and international arbitration was regulated by our former Civil Procedure Code, and this regulation was accepting appeals against arbitral awards, both in the field of national and international arbitration. After the implementation of Turkish International Arbitration Law, which regulates our international arbitration rules, it was accepted to file an action for setting aside arbitral awards as the only remedy in court against arbitral awards. With the implementation of our a new Turkish Civil Procedure Code, which regulates our national arbitration rules, it has been accepted to open an action for setting aside arbitral awards as the only remedy in the court against arbitral awards in the field of national arbitration. If the dispute that's the subject of arbitral decision has an international element in the sense of IL Article 1 and 2 and the place of arbitration is Turkey, an action for setting aside an arbitral award should be filed within the framework of IL Article 15. If the dispute in question does not contain an international element within the meaning of Article 1 and 2 of IL and the place of arbitration is Turkey, setting aside of arbitral awards is subject to CPC and the related article should be prosecuted. Now, only an action for setting aside can be filed against the arbitral award. Now I will examine the provisions related to setting aside procedure in international arbitration in IL, comparing with the provisions related to setting aside procedure regulated in CPC. I marked differences between the provisions with bold, and if there is an important difference, I will explain that additionally. In both provision, in the first sentence, only an action for setting aside can be filed against the arbitral award. The action for setting aside is filed in the competent court, regional courts of appeals, and is prosecuted in priority and promptness. But what's the competent court? The competent court is the defendant's place of residence or ordinary residence or the place where the workplace is. If the defendant does not have a place of residence, ordinary residence or workplace in Turkey, Istanbul Regional Courts of Appeals is in charge and competent. In national arbitration in CPC, Regional Court of Appeals at the place of arbitration is in charge and competent. Where is the place of arbitration? Place of arbitration shall be freely decided by the parties or by the arbitration institution chosen by them. If there is no agreement on this matter, the place of arbitration is determined by the arbitrator or the arbitral tribunal according to the characteristic of the case. The arbitral award shall be deemed to have been rendered at the place of arbitration and on the date specified in the award. In Turkish arbitration law, there has been made a lot of legislative changes concerning the court in charge for the action of setting aside arbitral awards. As a result of these legislative changes in practice, it resulted for a period a double control, for another period three-party control mechanism. Finally, after 2018, it's accepted to file an action for setting aside only before regional courts of appeal, and we switched again double control mechanism. Because after setting aside case, it's possible to file a case against regional courts of appeal decision before Supreme Court of Appeals. Time limits for an action to set aside. An action to set aside an arbitral award can be filed within 30 days in CPC in 1 month. If on an application against the arbitral award for its correction, interpretation, or completion has been made before the arbitral tribunal, an action for setting aside can be filed in courts of the place of arbitration within the legal period determined according to the laws of the place of arbitration as of the notification of the award rendered as a result of the examination made in line with these requests. I will talk about the effect of claim for setting aside on the enforcement of the arbitral award. An action to set aside an arbitral award automatically suspends the enforcement of the arbitral award. This provision is criticized, and the doctrine is entirely in the same opinion that this provision should be changed, and until this legislative changes, the court should render a judgment for compensation for misconduct. As it's newer legislation, according to CPC, an action to set aside an arbitral award does not suspend the enforcement of the arbitral award. However, upon the request of one of the parties, the enforcement of the award may be suspended, provided that a security is presented to cover the value of the awarded money or property. The parties may partially or entirely waive their right to file an action to set aside an arbitral award before the final arbitral award is served on them. Parties whose domiciles or ordinary residences are outside of Turkey may waive their right to file an action to set aside an arbitral award by an express statement which they put into the arbitration agreement or by an agreement in writing afterwards. They may also waive their right to file an action to set aside an arbitral award for one or more of the reasons listed above. The parties in national arbitration, the parties cannot partially or entirely waive their right to file an action for setting aside before the final arbitral award is served on them. If one of the parties to the dispute is domiciled in Turkey in international arbitration and the other is outside of Turkey, it's not possible for the parties to waive their right to file an action for setting aside partially or entirely before the arbitral award is served on them. Here it should be noted that both for national and international arbitration, legal remedies cannot be waived against the final judgment rendered as a result of the action for setting aside before the notification of final judgment to the parties. Now we will examine the reasons in both national and international arbitration. We will see the reasons are the same with small differences. In IAL Article 15, there are two parts regulating the grounds, subparagraph 1 and 2 of paragraph A of Article 15. The first paragraph regulates the grounds which should be taken into consideration by the court upon request and if proved. The second subparagraph regulates the grounds which should be taken into consideration by the court ex officio. However, in CPC, all the grounds should be taken into account by the court ex officio. But in CPC, there is a provision regulating waiver of the right to object in national arbitration. According to the related article, if a provision that the parties may decide to the contrary or arbitration agreement is violated, the relevant party may object to this contradiction. If the interested party continues to arbitrate without objecting within 2 weeks or within the period agreed by the arbitrators on this matter from the date of learning of the violation, it shall be deemed to have waived its right to object. Although there is no provision in this regard in IL, the application is the same as stated in CPC. Now the grounds in international arbitration law. An arbitral award may only be set aside in the following grounds if the party making the application proves that one of the parties to the arbitration agreement is incompetent to sign this arbitration agreement, or the agreement is invalid according to the applying clause stated in arbitration agreement. if there is no such choice of law, Turkish law. In this case, arbitration proceedings cannot be continued. However, this ground only constitutes a ground for setting aside in the event that the party raise a motion contesting the jurisdiction of the arbitral tribunal on the ground that a valid arbitration agreement does not exist before submitting a defense. If not, the right to rely on this letter in the arbitral proceedings or at the court is waived unless this motion is made on the ground that the dispute is not capable of being settled by the arbitration. The second ground, in the selection of arbitrator or the arbitral tribunal, the procedure determined in the arbitration agreement or stipulated in this law is not followed. In this case, arbitration proceedings can be continued. Re-arbitration is possible. But however, to accept the claim of setting aside on this ground, the party must raise a motion again. The third reason, the decision was not rendered within the arbitration period. In this case, the arbitration proceedings cannot be continued. The fourth reasons, the arbitrator or the arbitral tribunal has decided unlawfully that it is competent or incompetent for the jurisdiction. Arbitration proceedings can be continued in this case. Re-arbitration is possible, but a motion must be raised in arbitration proceedings again. The fifth reason, the arbitrator or arbitral tribunal has decided on a subject excluded in the arbitration agreement or has not decided on each claim or has exceeded its competence. In this case, arbitration proceedings can be continued and re-arbitration is possible. The decision for setting aside the final arbitral award may be partially if the part to be set aside is separable from any part. The second reason is arbitration proceedings were not conducted in accordance with the agreement of the parties in terms of procedure or in the absence of such agreements in accordance with the law, and this situation is mainly affected the arbitral award. In this case, arbitration proceedings can be continued. Re-arbitration is possible. The principle of equity of the parties is not observed during jurisdiction is another reason for setting aside. Arbitration proceedings can be continued in this case, and re-arbitration is possible. There are just two reasons regulated in paragraph 2, which should be taken into consideration by the court ex officio. If determined ex officio by the regional courts of appeals, the dispute proceedings cannot be continued. The decision is contrary to public order. It's international, substantial, and procedural public order, not Turkish nation. Arbitration proceedings can be continued in international arbitration, but in national arbitration, not continued. Re-arbitration is not possible.
I'm sorry, there are problems in connection in transmission.
Only slides, last 4 slides.
Hello?
Okay, last 4 slides.
So, but
yes.
using this opportunity, may I ask you, Professor, just to summarize very briefly the rest of your presentation? We are really in very short in time.
Okay. Maybe I would like to mention about enforcement of arbitral awards. It is.
However, just please one remark: enforcement of arbitral awards is subject of the session 3.
Okay, then I can finish. Okay.
Okay. Thank you. Thank you, Professor Schintz-Market. Thank you very much. It was very informing and very interesting. However, before closing this session, let me to inform you we have received one question from one of the attendees, namely, if there is a court practice already regarding application of sanctions in set-aside proceedings. Just briefly, from the Czech point of view, there is no practice in that respect, and it hardly can be, because all substantive issues cannot be subject of set-aside proceedings. It means, yeah, of course, we don't know how the practice will be in the future.
It's the same in Turkish law.
Yeah, the same. Yeah.
No
substantive issues. Yeah. So
yes.
in the Czech Republic, there is no practice, and
yes.
you hardly can imagine that sanctions can be subject of applications in set-aside proceedings. In Turkey, the same. Yeah.
Yes, the same.
Yeah. Okay. Thank you very much. And I do know we are in delay. However, the set-aside issues are very, very important in all jurisdictions. Thank you very much. And returning the word to Istanbul.
Thank you very much. Since we just have 5 minutes left in the last session, let me just very fastly connect to Professor Yeşilermak, who I don't see with us right now. Oh, he's here now. I'm sorry.
He's getting connected.
Yeah. So the session 3 is about the recognition and the enforcement of the foreign arbitral awards. And the moderator is Professor Dr. Ali Yeşilermak, the member of the İTOTAM Arbitration Court. Can you hear us, Professor Yeşilermak?
Yes.
Yes.
I certainly hear you. Thank you very much.
You have the floor.
Dear colleagues, dear participants, welcome to session 3. We will be speaking about recognition and enforcement of foreign arbitral awards in this session. And we have 2 panelists. First one is Assistant Professor Dr. Ekin Ömeroğlu. Ekin Ömeroğlu has a BA degree in law from Istanbul University, and she completed LLM in private law, again in Istanbul University, and she obtained her PhD degree from the same university. Her focus is on arbitration and private international law. She has written on arbitration as well. Her LLM thesis is on arbitration, evidence in international commercial arbitration. And she's a lecturer at Kadir Has University. And currently she is a visiting scholar at Heidelberg University Institute for Comparative Law, Conflicts of Law, and International Business Law in Germany. Ekin, the floor is yours.
Thank you, Professor Yeşilermak. First, I would like to share my screen. And first, I also want to thank to the Istanbul Chamber of Commerce Arbitration and Mediation Center for this invitation. It is really a great honor to be on this panel. Since the subject we will discuss today is wide-ranging, I will try to explain the enforcement of foreign arbitral awards in Turkey with its main lines and with the court decisions. The provisions of Articles 60 and 62 of the Turkish pro-international law include the recognition and enforcement of foreign arbitral awards. However, Turkey has also been a party to international arbitration agreements regulating the same issues. For this reason, it is necessary to determine which rules will be applied, even though a subject falls within the scope of Turkish law and international agreements to which Turkey is a party. According to Article 90 of the Turkish Constitution, international conventions and treaties duly signed and ratified by the Turkish Republic have the same effect as statutory provisions in the hierarchy of norms. Turkey has been a signatory of the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, and the Turkish Parliament ratified the New York Convention in 1992. Since many states are party to the New York Convention, arbitral awards rendered in contracting states will be enforced in Turkey in accordance with the New York Convention. The provisions of TPIL will be applicable where the arbitral award is not within the scope of the New York Convention. And Article 1 of the New York Convention clearly states which decisions are enforceable within the scope of the Convention. Article 1 and Paragraph 1 contains two definitions for a foreign arbitral award. The first definition is an award made in the territory of a state other than the state where recognition and enforcement are sought. However, in Article 1 and Paragraph 3 of the Convention, accept the principle that jurisdictions may, during the approval phase, limit the scope of the application of the Convention to arbitral awards rendered in the member states. Turkey has ratified the Convention with this reservation. For this reason, the New York Convention will be applicable in Turkey only with respect to the recognition and enforcement of arbitral awards rendered in a member state. The second definition of a foreign arbitral award is an award which is not considered as domestic award in the state where the recognition and enforcement are sought. And this means that if arbitral proceedings were not conducted in Turkish civil procedural law or the Turkish International Arbitration Act, the award rendered is deemed non-domestic under Turkish law. Thus, arbitral awards rendered outside of Turkey, irrespective of whether the arbitral proceedings were conducted under Turkish laws or not, fall within the scope of the New York Convention, because these awards are deemed as foreign arbitral awards. According to the New York Convention, contracting states may, when ratifying the convention, declare that the convention shall be applicable only to the recognition and enforcement of arbitral awards concerning disputes that are deemed commercial under their domestic laws. Turkey also made a declaration when ratifying the convention. For this reason, the convention is applicable in Turkey only to arbitral awards that concerns disputes arising from relationships that are considered commercial under Turkish law. Since the concept of commercial affair has been defined widely in a Turkish commercial code, this declaration does not limit the applicability of the convention to a great extent. Procedural rules regarding recognition and enforcement within the scope of the New York Convention are subject to national laws of contracting states. Therefore, procedural issues that occur under the lawsuits for enforcement of foreign arbitral award that fall within the scope of application of New York Convention, such as the court's competence and jurisdiction, the type and amount of the court fees, the form of trial proceedings, are to be determined considering the procedure law of the Lex 40 under the Turkish law. Therefore, procedure and enforcement is determined under the international law in Turkey. According to Article 60 of Turkish international law, the court that has subject matter jurisdiction with respect to the enforcement of foreign arbitral awards is the court of first instance. In terms of the division between the Turkish courts of first instance as civil courts of first instance, commercial courts, family courts, commercial courts of first instance are granted subject matter jurisdiction in respect of lawsuits for the recognition and enforcement of foreign arbitral awards. In Turkish law, it is prohibited to review the decision regarding material and legal facts in the recognition enforcement of foreign arbitral awards. In other words, the court will only examine whether the judgment sought to be recognized or enforced meets the conditions of recognition enforcement. This situation has been clearly emphasized in the decisions of the Turkish Court of Cassation. And when we look at the conditions for enforcement of foreign arbitral awards, they are listed according to the numerous clauses principle in Article 5 of the New York Convention. And accordingly, the following must be met in this arbitral award. There must be a relevant arbitration agreements between the parties. Award must have been rendered in compliance with the defense rights of the defendants. Award must have been rendered by the arbitrators within the scope of the submission to arbitration. Composition of the arbitral tribunal or the arbitral procedure must be in accordance with the parties' agreements, or in the absence thereof, in accordance with the law of the place of arbitration. Award must have become binding on the parties or must not have been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. Award must concern a dispute that is arbitrable pursuant to the laws of the enforcement state. And finally, award must not violate the enforcement state's public policy. It should be noted that in cases of recognition enforcement of foreign arbitral awards, even if one of the reasons listed in Article 5 occurs, the court is not obliged to reject the request for the recognition enforcement because the concept of may be refused used in Article 5 of the New York Convention. And continue with the conditions of the enforcement of the foreign award. First, there must be a valid arbitration agreement between the parties. The parties have to clearly indicate the arbitral institutions they have chosen in the arbitration agreement. If the arbitration institution selected by the parties is not clear, the Court of Cassation may refuse the enforcement of the arbitral award because it's possible to resolve disputes through arbitration only if the parties agree on this issue. For a valid arbitration agreement, the arbitration agreement must be signed by the parties, or this matter must be agreed upon in the written communication between the parties. This condition was clearly emphasized in a decision of the Court of Cassation, 19th Civil Division of the Court of Cassation, and an agreement which does not bear the defendant's signature cannot be accepted as an arbitration agreement. For the arbitration clause to be valid in Turkish law, the parties will to arbitrate must be understood without hesitation. In cases where the arbitration agreement is not without hesitation, such as when the parties choose both the state court and the arbitration, the Court of Cassation rules that the arbitration clause is invalid. In the dispute, which is the subject of another decision of the Court of Cassation, it has been decided that all kinds of conflicts that may arise from the implementation of the contract will be resolved through arbitration. Still, the parties have agreed that Istanbul courts and enforcement offices are authorized in matters that cannot be resolved through arbitration, and in cases specified in the contract and its annexes. The Court of Cassation decided that the arbitration clause was invalid because the authorization of the courts and arbitration eliminated the absolute and final nature of the arbitration will. However, in a more recent decision of the Court of Cassation, the parties accept that in case of disputes, the Chamber of Commerce arbitration rules are in charge and authorized within the framework of the arbitration rules of the Chamber of Commerce. Although it is not possible for the Chamber of Commerce arbitration boards to perform this duty, the Istanbul courts and enforcement officers are authorized, stating that the parties declare and undertake is valid, and rejected the request for annulment of the arbitral award. In reasoning of the Court of Cassation, and I'm quoting, as can be seen, the will of the party, will of the arbitration has not been abandoned in the regulation in the supplementary agreement. Exceptionally, if it is not possible for the Chamber of Commerce Arbitration Boards to perform its duty, it has been accepted that Istanbul courts and enforcement offices are authorized. Therefore, it will be necessary to accept that the arbitration agreement between the parties is valid. The second condition for enforcement of the foreign arbitral awards, the award must have been rendered in compliance with the defense rights of the defendant. The parties must be treated equally in the arbitration proceedings. The parties cannot voluntarily abandon the principle of equality. A failure of the parties to be informed of the arbitration procedure will hinder the enforcement of the arbitral award. In arbitration proceedings, the parties should be allowed to make claims and defenses related to the proceedings. This opportunity will only be used if the parties are aware of the arbitration procedure. For this reason, the notification of the case has a particular importance in terms of the right to be heard. On the assumption that the defendant is not notified during the arbitration proceedings and the defendant cannot exercise his or her right to be heard, in that case, a valid and an enforceable arbitral award cannot be mentioned. Upon the defendant's claim that no information was given to him or her about the arbitration proceedings, the Court of Cassation ordered that documents showing that notifications were made should be submitted. And since the documents showing that notification was made were not submitted to the Court of Cassation decided that the defendant's right to defense was violated. Violation of the right to be heard is closely related to the concept of violation of public policy as well. However, in the New York Convention, these two concepts are regulated differently as reasons preventing the enforcement of the arbitral award. While the violation of the right to be heard is a reason to refer enforcement requests that only be considered upon the objection of the defendant. However, the cases of violation of public policy must be taken account by the judge ex officio. In order to cause rejection of the enforcement of arbitral award due to the violation of the right to be heard, the defendant must have filed a timely objection to the violation of the right to be heard before the arbitral tribunal. If the necessary objections are made before the arbitral tribunal in time, but it is not ensured that these violations do not affect the merits of the decision, only in this case the enforcement can be appealed, because if a fault made by the arbitrator regarding the observance of the rights to be heard illegally is remedied during the arbitration, the arbitral award will not be rejected on the ground that the right to be heard is no longer observed. However, if the relevant party was actually aware of the issues to be communicated in such a way as to make a counterclaim, despite not being duly notified, it can no longer be claimed that the right to be heard has been violated. The Court of Cassation stated that the party who did not make a claim about the impartiality and independence of the arbitrator during the arbitration proceeding, but made a claim after the arbitral award was rendered, acted in a contradictory manner. Composition of the arbitral tribunal or the arbitral procedure must be in accordance with the parties' agreements, in the absence thereof, in accordance with the law of the place of arbitration. The dispute on the number of arbitrators came before the Court of Cassation due to a lawsuit filed for the enforcement of a foreign arbitral award. Accordingly, the parties agreed in their agreement to resolve the disputes according to the rules of the International Chamber of Commerce. Since they could not agree on the number of arbitrators, a sole arbitrator was appointed by the ICC to resolve the dispute. When the arbitral award requested for enforcement in Turkey, the defendant made an objection and stated that the number of arbitrators was determined in violation of the Turkish international arbitration law. The Court of Cassation decided that in cases where the parties did not determine the number of arbitrators and the number of arbitrators was determined according to the rules of the chosen arbitration institution, it would not result in the rejection of the request for enforcement. And it should be noted that although the names of the arbitrator or arbitral tribunal that will resolve the dispute are specified in the arbitration agreement, the fact that the dispute has been determined determined by another arbitrator may result in the rejection of the request for enforcement. Because here the parties have now gone beyond the procedure of appointing an arbitrator and have determined who the arbitrator will be, and disregarding the intention of the parties will result in the arbitral award not being enforced. Another condition for enforcement of the foreign arbitral award is award must have become binding on the parties or must have been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. The concept of binding regulated in the New York Convention is different from the condition of finalization of the courts of foreign court or arbitral decisions. The Court of Cassation clearly emphasized the difference in one of its decisions and stated that in the Article 5 and paragraph E of the New York Convention, the bindingness of arbitral award does not mean submitting a finalized arbitral award to the court. While examining whether the arbitral award is binding, the Court of Cassation looked at whether there was a question of re-examination of the arbitral award, whose enforcement was requested in a high-level arbitral tribunal or state judiciary. And here's a question that if a case for annulment has been filed against the foreign arbitral decision but has not yet been concluded, can this arbitral award be enforced in Turkey? The Court of Cassation stated that if an annulment case has been filed against the arbitral award in the country where it was ruled, the decision regarding the annulment case must be final for the arbitral award to be enforced in Turkey. Accordingly, one of the decisions of Court of Cassation, it was stated that the enforcement of the arbitral award could not be decided in Turkey since the case for annulment could not be proven to be final. And continue with the award must concern a dispute is arbitrable pursuant to the laws of the enforcement state. As Professor Demir Gökyayla was mentioned before, according to the Turkish International Arbitration Law and the Turkish Procedural Law, disputes that are not subject to the parties' will and disputes arising from the rights in rem on an immovable property located within Turkey are regulated as not arbitrable. For this reason, it cannot be claimed that a dispute regarding an immovable property that is not located in Turkey is not suitable for arbitration under Turkish International Arbitration Law. If the dispute regarding an immovable property located outside of Turkey is deemed to be arbitrable in terms of the law of the country where the immovable is located, there will be no reason to invalidate the arbitration clause. The reason why the disputes regarding real rights on immovable property located in Turkey are not allowed to be resolved through arbitration is because these disputes are considered essential for the Turkish public policy and therefore should be resolved only by the Turkish courts. Disputes that are not related to the rights in rem on immovable property located within Turkey are arbitrable. For example, the non-compliance arising from a work contract related to the construction of an immovable can be resolved by arbitration. However, the Court of Cassation does not allow the resolution of title deed cancellation and registration cases through arbitration, even if they are related to the work contract. And finally, award must not violate the enforcement state's public policy. In accordance with Article 5, paragraph 2 and B for foreign arbitral awards to be recognized and enforced in Turkey, the award must not violate Turkish public policy. The grounds for refusal of enforcement of an arbitral award for reasons of public policy pursuant to Article 5 of the New York Convention is to be considered in light of the public policy of the state where enforcement is sought. However, the criteria to be taken into account in determining violation of public policy have not been expressed in the convention, and the determination of this matter is left totally the determination of the court. The 15th Civil Chamber of the Court of Cassation in its decision dated 2014 on the enforcement of foreign arbitral awards interpreted the public policy as the basic values of Turkish law, general morality, and the basic understanding of justice and the legal policy on which Turkish laws are based, the fundamental rights and freedoms in Turkish constitution, the understanding of morality and justice adopted by developed societies. Since the understanding of public policy changes over time, it is necessary to look at the purpose of public policy in every particular case. According to the general view in the Turkish doctrine, the fact that a foreign arbitral award is contrary to Turkish law does not, as a rule, prevent the enforcement of this decision. In its decisions of the Court of Cassation did not find that the foreign arbitral award was contrary to the mandatory provisions of Turkish law, considering the characteristics of the case, not contrary to public policy. Serious procedural faults in the foreign arbitral award, in particular violation of fundamental human rights during the arbitration proceedings, and hiding the information and documents, evidences submitted to the file from of the one parties, will prevent the enforcement of foreign arbitral award. The fact that the foreign arbitral award is related to the same subject as finalized Turkish court decision will prevent enforcement of the foreign arbitral award in Turkey within the scope of public policy. There is no difference whether a Turkish court decision is a court of first instance or the court of appeal or court of cassation decision. Moreover, it does not matter which court renders the decision. The court might be a criminal court, administrative court, tax court, etc. And when we look at another decision of the Court of Cassation, it is concluded that the ICC arbitral award could not be enforced in Turkey under public policy, since the ICC arbitral decision conflicts with the final decision of the tax court from Turkey. And lastly, the grounds for refusal under the Turkish international law, the provisions of the TPIL, regulating the enforcement of foreign arbitral awards, were adapted from the New York Convention. The conditions for enforcement set out in the Article 62 of the TPIL and the burden of proof are in harmony with the conditions of enforcement listed in the New York Convention. Therefore, the explanations we made with regards to the New York Convention are equally applicable with respect to the Turkish international law. And thank you very much for listening to me. And again, thank you for the kind invitation to this panel.
Thank you very much, Dr. Ömeroğlu, for thorough analysis of Turkish law. Now the floor is Professor Bela Flavakis, is going to explain status under Czechoslovak Republic. Professor?
Thank you. Thank you very much. Let me to introduce briefly the situation in the Czech Republic, the practice and recognition and enforcement of foreign arbitral awards. As I already mentioned during the session 1, arbitration has a long-standing tradition in the Czech Republic. If you look at the statutes chart of the New York Convention, you will see that Czech Republic is bound by the New York Convention only since January 1st, 1993. However, this is only because Czech Republic is the successor of the former Czechoslovakia. In the former Czechoslovakia was one of the initiators of the New York Convention and very actively, in a very active manner, took part in drafting and negotiating the New York Convention in the course of the 50s of the last century, and was one of the very first signatories of the convention. Also, the former Czechoslovakia ratified the New York Convention very quickly and is bound by the New York Convention since the late 1961. That's why there is a long-standing tradition in applying the New York Convention since over 60 years currently. There is therefore a very constant practice in application. The application of international treaties, or let's say of law of international cross-border origin, has the priority in application of the law, both pursuant to the Private International Law Act as well as pursuant to the Czech Constitution. That's why if recognizing and enforcing foreign arbitral awards, first international treaties come to application, and due to the number of signatories of the New York Convention, usually the New York Convention the New York Convention applies. I have a little bit easier job in this moment because my predecessor, Professor Emeroglu, very precisely summarized the New York Convention. It is also to be mentioned that the Czech Republic, or respectively the former Czechoslovakia, entered into a very large number of bilateral international treaties in terms of legal assistance treaties with a high number of countries, and many of them also stipulates for recognition and enforcement of foreign arbitral awards. Just in respect to the European countries, there are such countries like Albania, Bosnia and Herzegovina, Montenegro, Croatia, Portugal, Romania, Slovakia, Slovenia, Serbia, Spain, Switzerland, Ukraine. All of those legal assistance treaties also set for recognition and enforcement of foreign arbitral awards. Much more, some of them also set for identification and application of foreign law in arbitration, like, for instance, the legal assistance treaty with Hungary. It is a question which international treaties take the priority in application, if the bilateral legal assistance treaties or the New York Convention treaties. It is not clear both in theory as well as in practice. However, in fact, both kinds of treaties, New York Convention, bilateral treaties, set for almost compatible standards. Even some of the bilateral treaties set for a little bit more conventional standards in recognition and enforcement of foreign arbitral awards. The Czech Republic is bound also by a bilateral legal assistance treaties entered with Turkey in early 30s of the last century. However, due to the historical reasons, this legal assistance treaty does not set for recognition and enforcement of foreign arbitral awards, which became to be a standard in legal assistance treaties much later, mainly in the course of the 70s and 80s. As mentioned, the Czech Republic has a long-standing practice and tradition in application of the new convention, and in fact, we didn't identify when going through the application practice of the new convention any irregularities, and in fact there are not too many. There is not too many case law reported currently because there is a standard and traditional very broad trend in application of the international treaties. When recognizing and enforcing foreign arbitral awards, the practice of the Czech courts is very strict in terms to apply the reasons for potential for not recognition and not for enforcement of foreign arbitral awards in a very strict and narrow manner. The Czech law set for, as in respect to the law of national origin, the Czech law set for recognition and enforcement of foreign arbitral awards, also in the Private International Law Act as of 2012 and in force as of January 1st. 2014, which also set for the priority of application of international treaties. Which means the Private International Law Act applies only if the international treaties binding for the Czech Republic do not stipulate otherwise. Pursuant to the Private International Law Act, foreign arbitral award shall be recognized without any special decision being required. Foreign arbitral awards will be recognized by awards being taken simply into the consideration, which is a very informal approach. It means that if taking the decision on enforceability, the decision on the recognition needn't be taken explicitly. Enforcement of foreign arbitral awards must be reasoned by a decision of the Czech court. It means that the decision of the court must also bear the reasoning. The conditions for the recognition and enforcement of foreign arbitral awards are, first of all, the finality of the foreign arbitral award. Czech law has adopted a relatively strict approach to this issue. An arbitral award cannot be enforced in the Czech Republic unless it has become final, conclusive, and enforceable in the country in which it was made. Still, it is a question in the Czech Republic, how far to be applied the Section 5, Para 1 of the New York Convention in terms is the if the foreign arbitral award is enforceable in the Czech Republic and may be subject of recognition and enforcement if it has been set aside in the country of its origin. If applying only the New York Convention, the Czech court is not bound by the decision of a foreign court setting aside the foreign arbitral awards. On the other side, if applying the private international law acts in terms of the law of the national origin, the Czech court would be bound and would have to reflect a foreign decision on setting aside a foreign arbitral award. However, the doctrine and practice is not fully clear in that respect, mainly because of still lacking decision-making practice and interpretation practice of the Czech Private International Law Act currently in force, which is in force only since almost 11 years. Might it be the future practice will bring a clear view on this issue. Another issue is the interpretation of public policy in the Czech Republic as one of the grounds for potential deny of recognition and enforcement of foreign arbitral awards, both pursuant to the Czech domestic law as well as pursuant to the New York Convention. As in respect to the interpretation of the public policy, the purpose of this provision is to prevent the legal effects of an arbitral award as an enforceable title, which would have undesirable effects contrary to the overriding mandatory principles, not overriding mandatory rules, but principles of the social and political order of the Czech Republic, of the country. The public policy in terms as a reason for deny of recognition and enforcement will be understood in the Czech Republic as most probably in the majority of another countries as a procedural public policy. It means not as a substantive public policy. Foreign arbitral awards in respect to the foreign arbitral awards, the public policy will be interpreted as less rigorous than public policy applicable to domestic decisions and in domestic legal matters. A decision is principally considered contrary to the public policy in terms of interpretation taken by the Czech courts and in the Czech practice. Is in contrary to the public policy if the effects thereof would conflict with the overriding mandatory principles of law or with the fundamental principles of the social order. In international issues, however, the application of the public policy reason for denying set aside and for denying recognition and enforcement of foreign public policy will come to the application, however, rather exceptionally. The Czech courts follow the interpretation of public policy terms currently typical for EU countries that public policy is rather exceptionally applicable institute. Also, the Czech Republic, the Czech interpretation, practice, theory, and theory follow the principle that the state of recognition is allowed to review the arbitral award from the perspective of compliance of its effects with the fundamental principles of the state's law only. Due to the absence of any uniform and internationally recognized definition of public policy, except of those from the 19th century, that it is a very unruly horse, as our English colleagues would say. The term of public policy must be interpreted in each individual case constantly with the case law and practice in the particular country of recognition and enforcement. Generally, a conflict with public policy would, pursuant to the Czech law and Czech doctrine, occur if the enforceability of the arbitral award were contrary to the fundamental principles of the constitutional and legal order, and as I already mentioned, also contrary to the social order and public social order. Conflict with public policy arises in those cases pursuant to the Czech practice where the fundamental rights were breached in the proceedings. The concept of public policy ought to be interpreted, that's why in a relatively strict manner. This applies for international arbitral awards, for foreign arbitral awards, and we are happy to have some such a broad practice in applying the international treaties. That's why, in fact, there is no specific practice, and the Czech practice in application of the international treaties, mainly the New Convention, is very friendly to arbitration and supporting, that's why, the international commercial exchange. This is the view from the Czech perspective on recognition and enforcement of foreign arbitral awards. And because this is my conclusive and final word during this webinar, let me once more to express many thanks to our Istanbul seated colleagues. We are very positively thinking regarding our cooperation. We hope that this cooperation not only will be helpful to international arbitration practice, but also helpful to the commercial trade and investment exchange between both countries, which has a long-standing tradition, and we are happy to support this tradition. Once more, also let me to express many thanks to all institutions supporting our aims, and once more let me to mention both diplomatic and consular missions, the mission of the Czech Republic in Ankara and consular mission in Istanbul, and the diplomatic mission of the Republic of Turkey in Prague. And we were really very surprised, positively surprised, how the diplomatic mission and the consular mission and commercial missions replied to our information about the cooperation we entered only about half a year with ITOTAM. Thank you very much. And as mentioned, as I proposed to our Istanbul colleagues, it will be very helpful to our cooperation if the attendees of this webinar will address to both of us, to ITOTAM and to PRIAC, their suggestions and ideas regarding the cooperation in terms the cooperation will be will be helpful to the commercial exchange. Last but not least, let me to mention one issue, my idea, which I'm repeating very often. Arbitration is justice. Justice is not a business. However, it must be helpful and supporting the business. Thank you very much, and returning the word to Istanbul.
Thank you very much, Professor Berohlavek, for your valuable insights on Czech law regarding recognition and enforcement of arbitral awards. It seems there is no question, so I end the session again for thanking to you both, professors. And I also happen to be have the duty to end the webinar. We are also, like yourself, thankful to PRIAC, members of the court at PRIAC, ITOTAM, members of the court in ITOTAM, and all missions supporting us, all colleagues, professors, friends supporting us, organizing committee, and our people helping in the organization of this meeting. And we are also thankful to all participants for listening us. Please watch us. We will have further events, webinars, hopefully with our friends at PRIAC. Thank you very much. Goodbye.